Okay, good afternoon, everybody. Thank you for being with us today. On behalf of the Texas Indigent Defense Commission's Family Protection Mentorship Program, I'm happy to welcome you all to this presentation, Litigating Reasonable Efforts. Today, what we intend to talk about is how to advocate for children to remain or return home under the various provisions of the Texas Family Code, outlining requirements for findings by the court that address reasonable efforts at every stage of a case that don't involve aggravated circumstances. So this is an area of litigation that's quite frankly underutilized in our field, especially since the legislature strengthens requirements for findings in 2023. At each hearing and at every opportunity, advocates for parents and children really need to make sure that the court is addressing the question of what is the current immediate safety threat, why can the child not be returned home safely, and what specifically is the department doing to ensure those issues are addressed. Often parents are accused of just jumping through hoops, or when I was in practice doing these cases, the phrase that was often used is checking boxes, not taking their services seriously, not engaged. But on the other side, attorneys for parents and children really need to ensure that the department isn't just checking boxes themselves in cases that could involve unnecessary removal. Parents are often assigned needless services, and then the department does nothing to address otherwise surmountable obstacles that could be addressed with very little support for a struggling parent or family member of the child. So that's what brings us here today. Before I introduce our fabulous guest presenter, Cindy Dyar, I have a couple of housekeeping issues to address with you all. This program is recorded. It's going to be uploaded to TIDC's YouTube channel. For those who can't attend live, I'll send the link out to that recording to everyone after the presentation. The program is CLE accredited by the State Bar of Texas for 1 hours of CLE credit. It is titled Litigating Reasonable Efforts, and for those who can't see it in the chat, the CLE number is 174251636. With that, I am honored to introduce the inestimable Cindy Dyar. We are so very lucky to have Cindy presenting today. She is a managing attorney at the Texas Legal Services Center, where she oversees the Family Helpline and Kin Care Project. Before joining TLSC, she directed the Family Defense Project at Texas Rio Grande Legal Aid, representing indigent families in all stages of DFPS intervention across 68 counties, with a focus on pre-petition representation. She has over a decade of experience representing parents and children in termination cases at both the Travis County Office of Parental Representation, where I had the privilege of working with her, and the Travis County Office of Child Representation. I was privileged to shadow Cindy at OPR when I started, and she is a powerhouse litigator. She is an excellent advocate for clients in crisis, and I have firsthand knowledge that she is an excellent teacher. She's TBLS board certified in child welfare law, was a Darrow Scholar at the University of Michigan Law School, and student in the Child Advocacy Law Clinic. This is a true leader in our field who really knows her stuff, and we are very lucky to have her with us. So thank you, Cindy, for giving us this time and for all of your work. I'm going to turn it over to you.
Thanks, Natalie. I'm glad to be here, and thank you for the kind words. I think you've hyped me up too much versus what this is going to be. So yeah, I just want to be really clear that this is an overview, right? And the point of what I've put together is to plant seeds in your brain about where to look and how to think about this reasonable effort standard at every single hearing that you're in. It's not exhaustive, because honestly, we could do an 8-hour training on reasonable efforts and still not get to everything. So I just wanted to be aware, or make everyone aware that it is an overview. Okay, so this is what we're going to do today, right? We're going to go through the origin of reasonable efforts, the definitions, if any, that exist, why it matters, and how to use it. Really, this session should be entitled, Don't Forget That You're a Lawyer, right? And I say this because we're in a field where practitioners seem to forget we have a massive body of law that applies specifically to our CPS cases. And there's also a ton of CPS policy we should be drawing on as well. What we do notice is that people get caught up, practitioners and judges, in generalizing and using the same catchphrases and terminology in every case, forgetting that they should be going to the code and policy to know what the law actually requires and bolster their arguments and positions that way. What we typically have for reasonable efforts, even though as you'll learn throughout this presentation, what all is required, what we typically have at hearings is the department getting up and saying they've made reasonable efforts, no one asking any questions about that, and then everyone signing off on orders that have findings that the department met its duty of reasonable efforts. Even though the law requires specific findings on reasonable efforts at removals, adversary hearings, permanency and status hearings, and termination. And the law now, as of 2023, requires specific findings. Unfortunately, that's not what we're seeing happening in courtrooms across Texas every day. Family Helpline, where I just came over here in mid-October of this year, but I did summarize some of the court observation at the Family Helpline. In addition to, we're staffed by all attorneys at the Family Helpline who have child welfare experience to answer questions and provide legal information and referrals on CPS cases across the state, but also what the Family Helpline attorneys do is court observation across the state in CPS courts. And so last year they did court observation in, I think, about 19 or 20 counties last fiscal year, and took a specific reasonable efforts checklist for every stage of a case to those hearings to report back if anyone was bringing up the specific findings that are needed now for reasonable efforts and what the courts were doing. Unfortunately, in the majority of those observed hearings, nothing had changed about how reasonable efforts are actually handled. No testimony solicited, no evidence put on, and yet orders coming out of those hearings continue to reflect that reasonable efforts were made. I understand that is a very small section of what's happening across the state, and so I want to emphasize that I'm not saying that's happening in every courtroom, it's just what we've observed. So again, today is simply an overview, understanding why reasonable efforts are important to all cases, where to look for the guiding principles in law and policy, and then how to think through and use that law and policy to support reunification on your cases, whether you're representing children or parents. And so I want to talk a little bit about where this reasonable efforts language comes from. I personally find it helpful to understand why any of this matters, so it's clear why brushing over reasonable efforts at every hearing is problematic. So in 1980, Congress signed into law the Adoption Assistance and Child Welfare Act, or ACWA, which pushed federal reformation of the foster care system in all states. This legislation offered funding to states, but it was contingent on the states revamping their child welfare systems according to the structure provided by the federal government. And so if the states undertook that required restructuring, the federal government would then pay a portion of the state's child welfare services costs. ACWA required 3 major changes in the child welfare system, the first of which required that states make reasonable efforts to prevent the removal of children from their families by providing the necessary services. It did not define what reasonable efforts is. And then in 1997, Congress passed the Adoption and Safe Families Act, or ASFA, to fix some of the issues from ACWA. And ASFA also made extensive changes to Titles 4B and 4E of the Social Security Act, which are the main sources of federal money that get filtered and distributed to the states for child welfare and foster care. And so ASFA also included provisions for each state around reasonable efforts. And one of those is having each state define aggravated circumstances. As you might know, in Texas, aggravated circumstances is codified in Texas Family Code 262.2015. Basically, if you're not aware of what I'm talking about, aggravated circumstances is a specific finding a court can make to waive reasonable efforts and the associated service plan requirement based on very specific conduct defined in that code section. Also, ASFA tied reasonable efforts findings to the department's ability to claim Title IV-E reimbursement money. So what that means is if a court finds that efforts made by CPS do not meet the reasonable effort standard, the child's ineligible for foster care maintenance payments for the duration of the stay in foster care, thus shrinking the amount of money that states receive from the federal government. And so where is reasonable efforts defined? Well, this is it, right? These are the only sections that provide any clarity on how reasonable efforts are defined. Neither ASFA nor ACWA provided a definition for reasonable efforts, in effect, leaving interpretation up to state courts. From the Department of Health and Human Services, the federal department, back in the 90s, when this discussion of defining reasonable efforts came up, they said, and I quote, "We do not intend to define reasonable efforts. To do so would be a direct contradiction of the intent of the law. The statute requires that reasonable effort determinations be made on a case-by-case basis. We think any regulatory definition would either limit the court's ability to make determinations on a case-by-case basis or be so broad as to be ineffective." And so that's what we have as far as federal guidance. The next slide I'm going to show you shows the total guidance provided by the federal government on reasonable efforts. And you can see here the Texas provision in the Family Code, and this is the only one I could find that elaborates specifically on reasonable efforts, which doesn't really provide a lot more detail. This is the minimal federal guidance I was just referring to. And this came out, I want to say late 90s. And this is the most I could find on HHS providing some suggestions of what courts may consider when determining if reasonable efforts have been made. And again, this is guidance, it's not binding. I do think there's some interesting things to note in here as we continue on with today's presentation, including numbers 3, 4, and 5. So basically, state courts and legislatures were left to interpret the standard of reasonable efforts. So it's probably no surprise that it's defined differently in some states. It's not defined at all in others. And this has resulted in confusion about what specific department efforts are considered reasonable in order to meet this standard. So in Texas specifically, since that's where we all practice, I just wanted to note that reasonable efforts is used 7 times in Texas Family Code Chapter 161. That's the termination provisions. And reasonable efforts is used 19 times in Chapter 262, which is temporary managing conservatorship cases. So it is scattered all throughout our applicable code. In 2023, for cases that were filed, this came into effect September 1st of 2023, for cases that were filed after that date, there were significant and substantial statutory changes that created additional reasonable efforts requirements for both the department and courts at removal, adversary, permanency, and trial. We still don't have a definition, but we have more guidance now in our code. So House Bill 1087 back in 2023 amended portions of Texas Family Code 161.001, 262.101, 262.102, 262.107, and 262.201. It also amended, well, House Bill 968 also passed in 2023, amended 262.101 and 102, 262.105, and 262.107. And I say this because we're going to walk through what is contained in the code for reasonable efforts at every stage. Many of those have changed or been added or fully amended in the last 14 months in September of 2023, although what's reflected in court hearings in many of the courts, you wouldn't know that these significant changes have been made. So this is what House Bill 968 did. I divided this up into what DFPS, what changed for them, and then what changed for courts. And so I did lift this, as I've noted, from the Children's Commission legislative session report, where they summarized last year all the significant changes that were made. And so I'm not going to read this to you, but you can see that there are now specific actions required by the department to be detailed in removal affidavits. And there's now specific requirements that judges make specific findings and removal orders around reasonable efforts. It added that when the department files a petition before or after removal, the affidavit must now include facts that the child wouldn't be adequately protected in the home with a kick-out order or a parent-child safety placement. And there's also now an added requirement for the department that removal affidavit must describe all reasonable efforts that were made to prevent removal, What this is saying is it's preventing just a clipped version of what we typically would see in pre-2023 affidavits of just the department made reasonable efforts. That's no longer good enough in Texas Family Code. You have to say specifically which efforts were made to prevent removal. And then what also changed and was also amended is to add in what's required in the removal order signed by a judge. And these are also specific findings that court has to make about kickout orders and PCSPs. So while the actual reasonable efforts finding language in these sections remains unchanged, to me, the required additions of kickout orders and PCSPs are now part of reasonable efforts inquiry. And now that there's the requirement for judges to make those findings on that, and for the department to include specifics on reasonable efforts, it should no longer fly if we just see the cribbed, copied and paste language from the code that reasonable efforts were made. And so this is what House Bill 1087 did. And again, this is a continuation of what I was just saying, right? And so significant and multiple provisions that are all centering around having to describe with specificity in both supporting documents filed by the department and then the court in its orders that reasonable efforts were made. So why does any of this matter? Well, it should matter to all of us. If you're removing children from a home, the department is required to make sure that's the only available safe option. And that before adding the trauma of a removal to the family, the department has made sure that no other person could take the child through a PCSP, or that, for instance, in a situation of domestic violence or abuse, the alleged perpetrator can't be booted from the home instead of removing the child. I would say that policy and lawmakers seem to have read the research over the last couple of decades about the trauma of removal. And you can see that reflected in the most recent laws and the push towards reunification and family instead of unrelated foster care. So now the law is really clear. Has every less extreme measure been taken before we remove this child from their home? And you can see that it's not just a reasonable efforts requirement at removal. The department and the courts are supposed to be taking and considering reasonable efforts throughout the entire legal case. At every hearing, there are reasonable efforts findings that are required to be made. We all know that there are plenty of courts in the state that run out the entire TMC case before returning children. And in some instances, that makes sense depending on that family's specific factual circumstances, but not in all. It would have been safe to do that before the 2023 changes, but now these required reasonable efforts findings are supposed to be made for a reason, right? So in a case, those findings could be made at removal, and then at the subsequent permanency hearing, we're not just supposed to focus on whether reasonable efforts were done before removal, right? We're supposed to be looking at from removal to permanency hearing, from removal to status, what additional reasonable efforts have been made. And then again at trial. And this shouldn't be the same evidence from removal. If the department hasn't continuously been making reasonable efforts, then the findings shouldn't continue to be made just because of what happened at removal. This also matters because it turns the focus to what the department should be doing. It's not just giving a parent a checklist of services used in every case and dusting off their hands. That's not reasonable efforts anymore. And so before we launch into specifics, I want to remind everyone about the standards of evidence as they change throughout a TMC case. And that matters because if an action by the department was considered a reasonable effort or reasonable efforts under the lowest standard of evidence, which is ordinary prudence and caution at the removal and adversary hearings, it might not still be a reasonable effort under preponderance. And it might not still be a reasonable effort under clear and convincing. And you can see as the case progresses, so does your standard of evidence. There's also a reminder here that the department has the burden of proof to show it's made reasonable efforts. That's not a burden someone else carries, right? Our job as attorneys for parents and children is to ensure that before the hearing, the department made reasonable efforts. So if they didn't, you're making that argument at the hearing and requesting that the court not make a reasonable efforts finding. What you should absolutely not be doing is signing orders that say there was a reasonable efforts finding and it's written in if it was never discussed at the hearing or in the reports leading up to the hearing. How is a judge signing an order that says DFPS made reasonable efforts as specific as required if no one said a word about it at the hearing and it doesn't appear in any of the pre-hearing court filings? And so we could do what so many in this practice do and run every case the same way, right? But every family is unique, as are their facts and circumstances. And reasonable effort should be defined for that family and those circumstances. If we are going to be left to our own devices, because the federal government wants us to define this on a case-by-case basis, then great, that gives us a lot of leeway. What it doesn't do in any way, shape, or form is allow us to skip over that finding at every hearing. I want to point out two tools that could be really helpful for you. I found them both helpful. The Children's Commission has a bench book that goes into this more in depth, but they also have bench cards, and those are for judges, but I use them all the time. And they list out the specific findings and citations that must be made at every hearing. And that's an easy handout to carry around. The other is the CPS Policy Handbook, which is available to search online. And so I just wanted to point out a reminder that only the department is bound by its policy. The court's not bound by it, nor is any other party. But it is chock full of what caseworkers are held to and what they're supposed to be doing by their own policy. So when the department has the burden to prove that they met the reasonable efforts requirement, you can absolutely cross-examine the caseworker on their own policy as it relates to reasonable effort, and then use that to ask the court to not make the finding. All right, so what I'm going to do now, we're going to go through ex parte hearings, adversary hearings, status and permanency hearings, and really briefly touch on trial, just to bring to the forefront what is required for reasonable efforts at each one of these hearings. And then we're going to talk about what's in CPS policy, just a sampling, and then start to think about what kinds of questions you can ask for each of these. And so here's the ex parte hearings. This is the code section for an emergency order authorizing possession of a child. So the removal statute. And I have a note in here that it's comparable to the 262.107 sections. That's the code section for removal of a child without a court order. And so I'm not going to copy and paste the same. It's the same language, right? Contained in if the department requests removal, goes to a judge before they remove or goes to a judge after they remove. The required findings language is the same. So I know it's also rare that attorneys might be at a removal hearing, but sometimes it happens if you're appointed to a court-ordered service or Chapter 264 case, and it turns into a removal case, or if you're privately retained and noticed of the ex parte. Regardless, you can carry over some of this to the adversary hearings as well. What I wanted to point out here, right, is what was added, and that's A4 and A5. A6 remains the same. This reasonable efforts language has been in here a very long time. But everything before A6 on this slide was added after 2023, and then subsection E was added as well. And so you can see, although no definition was added for reasonable efforts, requiring the court to find that a kick out of an alleged perpetrator, agreed or not, wasn't possible. And that a protective order wasn't possible. And I've noticed people skip over that protective order piece. In case you're not aware, the department is specifically authorized under the Family Code to apply for a regular protective order. That citation is Texas Family Code 82.002D2. It specifically authorizes the department to file a protective order for the protection of any person alleged to be a victim of family violence. And as you can see, this is now written into a finding that the court has to make before they can authorize removal. So for instance, in a domestic violence case, if a kick out order isn't possible, should be asked why the department isn't applying for a protective order for the rest of the family instead of removing the child. And because they don't want to is not, I don't see that as a permissible reason required or permitted by the law. And again, even though there's no definition added for reasonable efforts in A6, before signing a removal order, E requires the court now to find that a parent-child safety placement isn't possible for one of these three reasons listed. And so underneath each of these three reasons, there's a multitude of questions that should be asked, right? Who specifically did you offer the PCSP to? When? Why was there no time to offer a PCSP? Why specifically would a PCSP in this case result in immediate danger to the child? Because now the court's required to detail in a separate section of the removal order specifically what reasonable efforts were made. And that does not just allow for stating that the department made reasonable efforts and there was no time to do a PCSP. Why in this case? The other note, I didn't include this here, but the other amendments made to 262.101 and 262.105, those were also amended to require the department to include all of this in their in the removal affidavits. They have to specifically now state in their affidavits all reasonable efforts that were made to prevent removal. And they have to now, by law, describe with specificity in a separate section of that affidavit all of those reasonable efforts. This is just a sample of CPS policy. So that, again, that CPS policy handbook is available online and it's searchable. That search function was broken for several months and it was enraging, but it is fixed now and you can search everything. So I always do a search of code and a search of policy in whatever CPS hearing I'm headed to. And again, this is just a sample. This is not exhaustive. So you can see, right, under their 5412.11, the department, by its own policy, is specifically charged with attempting to implement a solution to the family's problems that is less extreme than a removal. And it tells CPS right here, right? They're bound by their own policy. And this is not in the Texas Family Code. Two additional things to consider for reasonable efforts: a safety plan, right? That would enable the child to remain in the home, or providing family-based safety services. So these are additional things you can draw upon when inquiring about reasonable efforts. Oops. And then you've got the requirements for completing a removal affidavit also linked here. These are just random questions I thought of when doing this slide. And these are just based on the law and policy, simply to show that there are plenty of things to ask about for every reasonable efforts prong. Every case is so unique, so I would imagine that questions for each of these would be very fact specific based on that affidavit and also what information you gather from your client, whether that's a parent or a child, about their version of what happened with reasonable efforts leading up to the removal. As we all know, you'll often get an additional story and that can be helpful at your hearing. But for instance, if domestic violence was the primary allegation supporting removal, maybe without conditions or maybe without additional concerns of substance use or physical abuse or things like that, I'd be drilling down on kick-out orders, PCSPs, safety plans, and protective orders, and wouldn't settle for the department saying they didn't have time to do those in a strict domestic violence case. And again, remember, what is reasonable efforts at removal is not the same as reasonable efforts at adversary and subsequent hearings. By then, it's reasonable efforts challenging why a child can't be returned home. So if you don't have time before removal to explore a PO or kick-out order, if I'm at an adversary status or permanency hearing, I'm wanting to know why you didn't have time between the removal and adversary, for instance, to file or explore those. And again, you can see I added in here questions surrounding safety plans because of the department's own policy, not the law. And this last question is directly from the department's own policy handbook. And so flipping over into adversary hearings, again, G2 and G3, those reasonable efforts, that's always, or for a very long time, as long as I've been practicing, that's been part of the family code sections already. What's changed, right, at an adversary hearing is what's listed down here in G. Now there has to be an order. Well, I'm sorry. Nope. Sorry. What's changed is what I didn't put on the slide, which is that now the court in an adversary hearing order, they have to describe in writing in a separate section the reasonable efforts that were made for all the sections you see on the screen. And so again, it's not enough in an adversary hearing just to leave it that reasonable efforts were made. There should be questioning if that's a contested hearing on what specifically was done. And the court shouldn't be making those findings if there's not evidence to support those reasonable efforts. And this is what I was saying previously in the prior slides is, for instance, using that same fact scenario from a strict domestic violence case. And you're at the adversary hearing. If they didn't have time to get a protective order or kick out order before removal, why not now? Thinking about this from a substance use case with a baby, perhaps, right, where mom tested positive at birth or in the hospital. Has inpatient rehab been explored for the mother and the child to go together? Why isn't that a safe option? You see, you can do this for any of the actual allegations and focus down on the factually specific things that are going on to sort out if the department has actually done reasonable efforts between removal and an adversary hearing. If we're flipping down to G1 subsection 2, right? This is the requirement for the department to make reasonable efforts to explore the non-offending parent or other conservator. So there should absolutely be evidence of the specific people the department tried to work with in this section. So which parent, managing conservator, possessory conservator, guardian, caretaker, or custodian entitled with possession did you contact since removal? CPS, what due diligence did you use to locate those people? What have you specifically done to enable that person's possession of the child? And so, yes, the big change in 2023 was 262.201G2. I don't have that on the slide, but that's if the court maintains the child in the department's temporary managing conservatorship. The court must describe in the adversary hearing orders in writing and in a separate section the reasonable efforts that were made to enable the child to return home, or the reasonable efforts that were made to enable a person's possession of the child. And that's speaking to the non-offending parent or other conservator piece of it. And so again, a court has to put those findings in. If evidence didn't come out on that, how are findings being made? I hope it's becoming clear as we're walking through these code sections that just saying reasonable efforts were made should never be enough under the current Texas law. And so again, this is just a sample of the CPS policy available surrounding adversary hearings. It does show that the department needs to be searching for relatives and exploring those options. And also gives additional bolstering to questions you can ask about reasonable efforts if you end up in a contested adversary hearing. And again, oops. These are just some sample questions, right? I would still harp, especially because most of us aren't at ex parte hearings, I would still harp on all of those pieces and questions that I had on the ex parte slide, right? But what have you specifically done since the removal to enable the child to return home? That's an added piece. Once the child is removed, you'll start to notice the statutes add this element in of what have you done to enable the child to return home instead of just what have you done to prevent removal. What specifically did you do to search for relative placements? When did you speak with them? Why aren't they an option? Have you requested any home studies? What did you specifically do to contact the non-offending parent? When, right? Not 15 minutes before this hearing started, but hopefully well before removal. What means did you use to contact them? Did you speak to any family about how to obtain that parent's contact information? How specifically does the person you locate present a danger to this specific child? And so, yeah, we've got status hearings, right? Of note is that no substantive changes were made in 2023 to reasonable efforts at status hearings. But I find, and so I think what happens is often people look at a status hearing almost as a throwaway hearing, but I find the opposite. I find them to be so incredibly important to the future of the case and where you can make a real difference for a family's chances at reunification, because it's all about the service plan, right? And so you can see in here that there is a reasonable efforts finding that needs to be made at a status hearing, and it does focus on the service plan. There are no specific lists of services, classes, or resources anywhere that CPS must offer to parents to satisfy the reasonable effort standard. It doesn't exist, right? What Texas law does tell us is the plan should be narrowly tailored to address specific issues for that case. That's B3. And that the court must issue findings that the plan, as long as it's a reunification goal, right? And again, not an aggravated circumstances case, as long as it's a reunification case, which if you're not ag circumstances, when you are at status hearing, should be reunification, right? That court must issue findings that that plan ensures reasonable efforts are made to enable the parents to provide a safe environment. And so does that mean a family plan of service should contain drug testing if there are no allegations of substance use? How's that narrowly tailored? What about the requirements for a psychological or psychiatric evaluation in every single service plan, especially in cases when there are zero indications of mental health concerns? Why is that a service? While the department and other advocates might find those useful tools, that's not nearly tailored nor reasonable. Also to consider, right? Is it reasonable efforts if CPS sends a bunch of referrals for services that have 6-month-long waiting lists? No. Or that CPS send families to services that require a 3-hour bus ride to get to when they know the family doesn't have transportation? No. It means the caseworker should be aware of the family's specific needs if they're following their own policy and the creation of service plans and making reasonable efforts to include services that are specifically geared towards that family and addressing the specific reasons why those specific children are in care. I know I've said specific probably 77 times in the last minute, but that is the language that's being used in the amended law, is specific. So I haven't used a synonym, and I'm sorry for how many times I've said it. I'm going to keep saying it. And so something here to also consider for service plans, right? As an example, CPS should ensure that services for children and families are geographically available, or they should be subject to a no reasonable efforts finding. Because while the family plan of service is not supposed to be a checklist just for the parents to check off, it's not supposed to be a checklist for the department either, hence the reasonable efforts requirements. There's a ton of policy on service plans. And I know this slide's messy, but I wanted to fit it all on this slide. This is just a sampling, right? I want to draw your attention to 5521.2 from the department's own handbook of the purpose of a service plan. And note what it says. I just copied and pasted all of these. I didn't mess with the language. If a service plan is well crafted with the parents and the parents meaningfully participate in the services identified by it, the child should usually be able to return home. This is how important a service plan is on every single TMC case. Also of note, from the department's own policy handbook, this does not mean that the parents have to complete every service in the plan for the child to be able to return home. So if you are in a jurisdiction when CPS and that judge like to see everything done, perhaps throwing this in here from the department's own handbook can help people understand the reasonable efforts piece is tailored to that specific family. Also of note, right, because I know this is not what's happening across the state, is under the department's own policy, the department is supposed to create that family plan of service with the parent, right? You can see that under 6242.3. State and federal law obligate CPS to jointly develop a family plan of service with each parent. And then it details, even if that's difficult for CPS, you still have to include the parent. And they give examples for incarceration and the parent resides outside of the jurisdiction. I'm aware of plenty of counties where the department develops its service plan, the caseworker does it, gets it approved by the supervisor, and puts it in front of the parent to sign after it's already been completed with the list of services and referrals. That's not jointly creating a service plan. Also of note is the parent's attorney has to be invited to any meeting about the family plan of service development. So if you're not getting invited to those meetings, that should be addressed on your local level. I don't interfere a lot when I come to those meetings initially, right? But I think if I start to see services that are being added that are unreachable, unworkable, or not related, I am going to interject on those pieces. You can also see, I always find this interesting under 6242.5, the content of that family plan of service, unless safety is an issue. The tasks and services in the plan must encourage contact, visitation, and other relationship building activities that may include the parent's attendance at medical appointments, school events, or other activities involving the child. So if you are seeing service plans where the visits are not even going to be allowed until a parent does X, X, or X, and it's not a safety concern because those visits are supervised at a CPS office, that's something to challenge for reasonable efforts. One last thing of note under 6242.41 is that the caseworker must inform each parent that they can invite relatives and fictive kin to participate in developing the plan. So again, if you have something where the department just hands the parent before court, at another meeting, an already completed service plan and ask them to sign it, that does not remotely qualify for the department's own policy, let alone the law. And so I think there's a lot you can do on reasonable efforts and service plans here. Again, these are just a sampling of questions, but it's really going to depend what you ask on the factual circumstances on that specific case. And if you have a caseworker that you work with a lot in a county and you see the same service plan on every single case, regardless of the allegations, I often think that's worth asking why. Okay, so now we've got permanency hearings. And so this is why it's so important to actually read the CPS court reports before every hearing, because the Texas Family Code, I think it's 263.303, requires the department to file those permanency hearing reports and serve them on everyone 10 days before the hearing. And those court reports must contain information necessary for the court to conduct the hearing and make its required findings under 263.306. We all know that there's limited time on the dockets, and so that's why a lot of the court report and required finding, or the court report covers the required findings with allegedly factual specifics for each case, so that the court doesn't have to have that all said on the record at a permanency hearing. But if it's not in the report and it's not said at the hearing, then again, how is the court making reasonable efforts findings? And what's important about the reasonable efforts requirements at permanency hearings is that it's about finalizing the permanency plan, including both the primary and concurrent permanency plans. And so those court reports should contain enough specifics about the actual actions the department is taking to finalize those plans. This section of the code, I think it's 263.303, also allows a parent's attorney, or the child's attorney or guardian ad litem to file a response to the report no later than the third day before the permanency hearing. And so what I would suggest on cases when you know that the department's not detailing reasonable efforts towards achieving permanency, primary and concurrent plans, is that you're really drilling down on those court reports that you were supposed to be receiving 10 days before, so that you have a chance to make a response in writing about the lack of reasonable efforts specifically on that case and file it before your permanency hearing. Some examples on this. If the concurrent plan is relative conservatorship, but no home studies have been done, nor have any relatives been spoken to, then I'd be very curious how the department was making reasonable efforts to finalize that concurrent goal. And you can do that for every one of the possible goals, right? What do they specifically need to do in order to ensure that this primary concurrent plan is a real thing? So again, just a selection of CPS policy you can use on your quest to sort reasonable efforts. And this is specific to things that go on around the permanency hearing times. Of note is that the family plan of service is supposed to be reviewed by the department twice more during the life of a TMC case at the 5th and ninth month. So if services haven't been set up from that original status hearing, family plan of service, or some services are no longer needed, or someone's still on a wait list, then those family plans of service, that should be caught, right, in the evaluations of the 5th and ninth month. And it should be amended. The family plan of service should be amended at that point. Instead, what we have, which is common, is no one's looking at that family plan of service from inception of the case until trial, right? And then realizing things haven't been done when this could have been dealt with along the way. You can also see here additional CPS policy of what they must include in the court reports regarding reasonable efforts in finalizing those plans. So if the plan is still reunification, but everyone's waiting on the parent to complete a service that they've been on a wait list for 6 months and it's not the parent's fault, why hasn't the department located another equivalent service to make reasonable efforts for their primary plan of reunification, right? Are they actually making reasonable efforts to reunify and achieve that plan? Or are they waiting for the parent to fail so they can switch plans and terminate? And this is why it's so important that at each stage you're evaluating those reasonable efforts. And again, these are just some samples, questions around it. Again, I expect most of these to be factually specific to that case, depending on what's in the court report and what information you're obtaining from your client and their service providers. But often I want to know if that caseworker, if they're saying the service was complete, but we still have concerns, right? Another catch-all word that's often used. What are those, right? Have you actually spoken to the service provider's caseworker? What are the specific concerns? What other services are needed to alleviate those concerns? But if all services are complete, what are we still waiting on? What steps has the department taken to finalize that concurrent plan? All right. So trial, this applies to all grounds. I consider this a pretty big change from September 1st, 2023. And so basically what this did, and I'm actually curious at the conclusion of this, and I only have a few more slides to know if anyone has seen a jury charge from a termination trial from a filing after September 1st of 2023, because I'm curious to know how this looks. And I'd also be curious to know in bench trials how this is being handled, because it's seemingly a third prong, right? We're so used to in terminations talking about the two prong that you must meet by clear and convincing evidence. One of the grounds from 161.001B1, and then best interest from B2. But this new code from last year under F basically says, that's great. You can have clear and convincing evidence for those two prongs, but if you did not do reasonable efforts, you don't get termination. Yeah, I think this is a huge deal, right? And again, the court is now required under G to include in a separate section of its order written findings describing with specificity the reasonable efforts the department's made to return the child to the child's home. And so I did not get a chance to do an exhaustive case law search on anything, and I think it's still a little bit early to see those cases on appeal. I could be wrong, but it should be, I would imagine, in the coming months. I'll be really interested to see if anyone is appealing specifically on this required reasonable elements finding. So something else, right, for trial, and this has come up in a lot of discussions around reasonable efforts. I don't know who, if anyone has tried or is aware of ICWA, the Indian Child Welfare Act, those cases that require active efforts. And so active efforts are more than reasonable efforts, and they also are specifically defined in ICWA. And so some states in the last few years have started to pull in those specifics from ICWA into their reasonable efforts, arguments, and findings on regular TMC cases. I believe there's actually 2 states that now view active efforts as reasonable efforts. And there's some case law around that requiring states to use active efforts in regular TMC cases. I think that's Colorado and California. And so Other practitioners, even though obviously in Texas, right, we're not doing that, other practitioners are looking to ICWA and what is defined as active efforts, um, and how ICWA treats those and what cases in ICWA or what courts in ICWA cases are considering active efforts and weaving in those examples into their arguments for reasonable efforts in Texas. It is definitely worth a look because there's a ton out there on the active efforts that are specific that make sense, right? Really pushing on transportation for services, really pushing on specific services that are tailored to that family. And I just threw up here on specific grounds just to not forget that there are two of the termination grounds that already have reasonable efforts woven in. This is both the inability to care under 161.003 and constructive abandonment, which is the end ground under 161.001B1. Both of these have long had reasonable efforts, and there is a fair amount of case law specific to these termination grounds on reasonable efforts that's worth looking up if you do go to trial on either one of those. And so in sum, I think what I want to leave you all with, and I know I've got a lot of time and I'm happy to answer questions, and we can just talk about these things, but what I want to leave you with is there is a fair amount of law and policy, and a lot of it is new in Texas over the last year. We have duties to our clients, whether we're representing parents or children, to know the law and policy and ensure, even though it is not our burden, that we are making every available argument around reasonable efforts at every single hearing and especially at trial. All right, that's all I have for my slides today. You're muted, Natalie.